Good afternoon. Good afternoon, gentlemen. Gentlemen, yeah. Looks like it's us three ladies with Life Legal. Okay, this is great. Okay. I'm Colette Wilson. I'm a lawyer, and I'm on the board of Life Legal Defense Foundation that's presenting this seminar today, and I've actually volunteered as a lawyer with Life Legal since going back to the days of Operation Rescue, which is back to the founding days of Life Legal. And this afternoon, it's so dark outside, our seminar is being presented by Katie Short, who's the legal director of Life Legal Defense Foundation. Katie graduated from Thomas Aquinas College in 1980 with a BA in liberal arts, and she then received her law degree from Boalt Hall in Berkeley. And Katie started in 1985 as a sidewalk counselor, counseling outside of abortion clinics, but she then began using her legal training to protect the rights of other pro-life activists. And I've known Katie back to those days of Operation Rescue, and I think Katie's been motivated a lot by the same thing that motivated me, and that was when I was getting arrested with Operation Rescue, and I just thought, as a lawyer, I could be helping protect the rights of these people that are out here saving babies, and that's what Katie's been doing since those early founding days of Operation Rescue. And we know that as you're helping people that are pro-life activists, those people are saving babies, and to me, I'm just like thinking it's almost like they're like firemen, that if their First Amendment rights are being restricted, they're like firemen locked in the firehouse. They can't get to the fire, and we as lawyers are who is going to help them get out there to save lives. So we're saving lives by helping those people be able to have their First Amendment rights exercised. And we also have with us Allison Aranda. She's staff attorney with Life Legal Defense Foundation, and I met Allison a few years ago and was instrumental in getting her to come over to be on our staff. But Allison will tell you that she just really couldn't believe, as her background is as a prosecutor, that people saving children's lives were being arrested. It's like prosecutors should be on the side of helping saving lives. So that's kind of a disconnect. And so she's using all those inside secrets she learned as a prosecutor to help protect those rights, and that's what these ladies are going to share with us today. So please, we're going to start with, I'm supposed to start out and tell you what we're going to talk about. Yeah, we're talking about types of speech activities. So actually, I've engaged in all of these. You see picketing, leafleting, sidewalk counseling, life chains, 40 days for life vigils. And I just would be curious to know, anybody here participate in any of those events? Yeah. Okay, good. And anyone here is a lawyer? Who here is a lawyer? This is great. So we're going to be going over the First Amendment. It's primarily the right of freedom of speech, but it also implicates freedom of assembly, freedom of religion, freedom of the press. And those are those topics that we're going to be covering, and learning how to effectively protect the rights of pro-life activists. Thank you.
Good afternoon. When we discuss about restrictions on free speech, usually the first question is the sort of forum in which the speech is taking place. They're generally the courts go through what's called a forum analysis, and starting with the least speech-friendly forum, there's the non-public forum, which is it's public property, but property which is in no sense been opened up. Military installations, the inside of a post office, the White House grounds, all public property, but in no sense have been opened up to speech activity. To the extent that they are, then any sort of restriction on the speech has to be reasonable in light of the use for which the property is actually dedicated, as well as not directed to a particular sort of speech. It has to be viewpoint neutral. Then you have another layer of the next step up would be the limited public forum, which is a forum that the government has actually created for speech. Examples would be street banners, public information kiosks, certain publications, things that are bus ad space on buses. All these are forums that the government creates, and because it has created them, and they're not traditional public forum, the government can make the rules for their use. And again, they have to be reasonable in light of the intended use and viewpoint neutral. And I don't know how many of you have seen the banners that are on Market Street, so the pro-abortion banners. Have everybody seen those? We've just been having a little dialogue with the city about those this past week, because the city had these it creates this forum for banners on light poles in public places, and it has the rules for the forum here in the city, which are pretty common. It was just intended to advertise events, or either specific like heritage things, special neighborhoods, things like that, or specific events that were taking place in the city. And then we noticed about 3 weeks ago that there were these banners showing up on Market Street that were basically simply pro-abortion propaganda. They had slogans on them. They just were the names of pro-abortion organizations. And so we did a little digging and found out that an organization had applied for the permit that was supposed to be in conjunction with an event that they were holding. And the more we dug, the more we found out that the whole thing just didn't hang together. They hadn't actually gotten a street closure permit for their event. They weren't, in fact, advertising their event anywhere. They were not. The event didn't have the required number of people that they said were going to attend. Unfortunately, just given the realities of time, we weren't able to do anything but establish a record that the city was not following its own rules about this, and we're hoping to have a little fun with that next year at the time of the Walk for Life, when maybe we get banners all up and down Market Street, pro-life banners. So the next designated public forum is property that the government sort of creates and dedicates to speech activity. And in those areas, they have the same rules basically as a traditional public forum. The rules, any restrictions have to be content neutral, narrowly tailored to serve a significant governmental interest, which we'll be talking about later, and leave open ample alternative channels of communication. So then the forum that we'll probably be dealing with, this is an example of a created public forum here, a little free speech area on a college campus, and that's where those sorts of rules would apply. You have to be content neutral. We're not going to get into the question of how much free speech rights you have on a college campus, because it's gotten to be extremely complex. It would take up a whole other hour just to go into that area, and the law is evolving as we speak. So, but it was the point was in the particular case, they do have to be content neutral restrictions, and they can't make a restriction on said it cannot engage in religious worship or instruction. In this one case, Orrin versus Barkley, which is in the materials, and they can't restrict the type of speech, which does come up with our clients, because there's a tendency to look at their, whether it's graphic signs or the literature, and then it's, oh, well, you're disturbing people, you're bothering people. We actually had a case in one college campus where an administrator was going through and saying, that sign's okay, that sign's not okay, that sign's okay, that sign's not okay. They can't do that. It has to be content neutral. The most common sort of forum that we'd be dealing with is the traditional public forum, which is streets, sidewalks, parks. They've been held to be traditionally dedicated for the use of the public for expressive purposes. And one of the questions that frequently comes up when dealing with a public forum, once you're in the public forum, it usually, and everybody admits it's a public forum, then you're going to get into about the questions of whether a limitation is reasonable or not. But the question of whether or not something is a public forum frequently comes up in the context of schools, because principals and administrators have a tendency to think that they own the sidewalk in front of their school. And we've seen that in many cases where the administrator will say, no, this is our sidewalk. And the good news is that because of the public forum test, that the question is not which entity, as long as we're talking two public entities, it doesn't matter whether it's owned by the city or it's owned by the school, if it is in fact open to the public and used as a sidewalk. In most cases, they're just flat out wrong. The school doesn't own the sidewalk. But even if they did, if you simply look down the sidewalk, is this sidewalk connected at both ends with other public sidewalks? Do pedestrians use it? Is it open for pedestrian passage? That is enough reason to say it is a traditional public forum, no matter which public entity owns the sidewalk. The other problem that we see sometimes with the schools is that there is a definition in the penal code of a safe school zone. And it defines a safe school zone as 1,000 feet around schools at certain times, before and after the opening and closing of the school day. And administrators and police sort of pounce on that safe school definition. But the problem is, in one of those legislative quirks, they create the definition and they did nothing with it. So you look through the rest of the section, and there's nothing really that says that. So what if something is a safe school zone? But they simply think the definition itself creates some zone in which they are entitled to make their own rules, and that's simply not the case. The test for restrictions on speech in a public forum are, again, content neutrality, narrowly tailored to serve a significant governmental interest, and leaves open ample alternative channels of communication. And the government has the burden, bears the burden of proving each of these elements in theory. As we'll hear a lot of things, there's a difference between theory and practice in a lot of these. And the content neutrality is the most important factor in terms of getting a restriction. It's the most clear-cut factor in terms of getting a restriction thrown out. Because the other factors we'll be discussing, narrowly tailored to serve a significant governmental interest, leaves open ample alternatives. Those are matters of degree. Is it narrowly tailored enough? Does it leave? What does it mean to be an ample alternative? Those are matters of degree. Content neutrality tends to be an up or down thing. Is this? Does it distinguish on the basis of content, or does it not? And if it does, it's either got to be backed up by a compelling state interest, which are few and far between, or it will be thrown out because to find something to be content-based, you're very, very close to getting it ruled unconstitutional altogether. The cases, for instance, in the Center for Bioethical Reform case, there was a case of what they call a truth truck being pulled around the block near a school, and they were pulled over and by the police, and the police were saying that they were disrupting the school atmosphere. And the Ninth Circuit upheld that this was an unlawful detention and arrest because it was based on the content of the speech, and that could not be a substitute. It could not be deemed to be disruptive simply based on the content of the speech. And in the ACLU versus City of Las Vegas is the Ninth Circuit at its most stringent in terms of content-based. It said you couldn't distinguish between commercial and non-commercial speech, which sometimes they do and sometimes they don't allow that sort of distinction. The other thing to look out for when another sort of content-based thing that might not immediately jump out at you is exemptions. When you have a sign ordinance or some, that's usually where it comes up, which has exceptions to it. And you might think, when you read through it, you say, okay, real estate signs, or for sale signs, open house signs, public information signs, things like that. Those are still content-based exceptions, and they have to be justified by some compelling state interest, or they have to well, the other thing that when you have too many of those exceptions, they start to undercut the entire rationale for the law itself. The courts have looked at it and said, well, you know, with even if they aren't strictly speaking content-based, but if you're allowing this many other signs, it sort of undercuts the city's rationale for having the law to begin with. Now, the narrowly tailored element, again, is one of the more slippery elements because, you know, there is different tests that courts use, and you can almost look at the decision and say, if it cites Ward versus Rock against racism, you're going to lose. If it cites Frisbee versus Schultz, you got a fighting chance. The Ward versus Rock against racism held that just because it has to be narrowly tailored doesn't mean it has to be the least restrictive means. It just has to be something where the end would be achieved less effectively absent the restriction, which is almost like saying it has to be totally irrational, because obviously any restriction is going to go somewhere towards achieving the city's goal of whatever the city's significant interest is. And significant interests come in, they can be very broad, very promoting pedestrian and traffic safety, aesthetics, interests like that are it's very easy for a city to come up with some way of connecting their restriction with an interest like that. So narrow tailoring is kind of a slippery concept, and I shouldn't get distracted by that. Again, some examples of the significant governmental interest, you could see that they're quite broad in their scope, as opposed to a compelling state interest, which are things like national security and protecting the well-being of minors from sexually explicit material, things like that. These are often in the eye of the beholder. The next category is whether a restriction, or the next piece of the test is whether a restriction leaves open ample alternative channels of communication. Again, this can be a very slippery concept that is applied. One can't help but think, depending on how the court looks at the underlying activity. For instance, in the Edwards case, the court struck down a prohibition on having sticks on signs in a parade, holding that restriction did not leave open ample alternatives, because if you're in a parade and you can't hoist your sign, then it can't be seen and you're deprived of your effective means of communication. The same Ninth Circuit 3 years earlier held that that restricting my client to a 3 square foot sign, not 3 by 3, total 3 square feet, was not overly restrictive. Still left him ample alternative channels of communication. So a lot of that is in the eye of the beholder in terms of whether your ample alternatives are adequate. And this particular prong tends to go hand in hand with the narrow tailoring. There are very few cases which rise or fall on the ample alternative means of communication. And then, as far as private property, we'll be talking later about, specifically in California, because in California we have greater free speech rights on private property. But generally speaking, there's no right to trespass. And specifically under the federal Constitution, there was a time when the Supreme Court sort of toyed with the idea of what we now think of as the pruneyard doctrine here in California, the idea that certain, like a shopping center or something like that, has been so opened up to the public that it's now a quasi-public forum. And the Supreme Court, again, toyed with the idea and then ultimately rejected it. So it's a state-by-state thing, whether the particular state's constitution allows speech or requires owners of private property to allow speech. So, and then I'm turn it over to Allison. Oh, yes.
So in California, certainly under the free speech clause in the California Constitution, large shopping malls have to allow the public areas of their shopping malls to be open.
Yeah, and we are specifically going to address that in the second part.
So in addition to the time, place, and manner restrictions that Katie just talked to you about, there are also permit requirements, or cities or counties may have permit requirements for various activities, whether it's to use a bullhorn, to leaflet, and those permit requirements also have to withstand constitutional scrutiny. Some instances where you might need a permit that are common are when you're requiring the sole use of a sidewalk, where you actually want to put up barricades and prevent other people from accessing a public sidewalk or an area of the park, or if you're going to be holding an event in a park, some cities require you to get a permit ahead of time. We'll go over when those various ordinances are constitutional and not, if the city is allowing if the city enacts these permit ordinances so that they can just monitor to make sure that there's not too many competing interests in the park at the same time, that would be a valid permit requirement. If it's just because they want a single person to apply for a permit, most often those are not going to be upheld as constitutional. Another instance would be if you have a group of about 50 or more participating at once. That's about the cutoff. Some courts have said greater than 75, greater than 100, but 50 is probably a fair number. If your assembly or your event is going to require, or you are expecting more than 50 people, you might be required to get a permit. And then also, like I said, the use of sound amplification devices. When you're evaluating a permit scheme, if you have a client who comes to you and says, I want to hold this event, are there any laws requiring me to get a permit? The test that you apply, there's 4 prongs to it. The first one, which you don't see in the other tests regarding time, place, and manner, is that there's no overly broad licensing discretion given to whether it's a single government official or a governing board who is responsible for granting the permit or denying the permit. This is probably the prong where most of the permit ordinances get struck down, is where the city is just giving carte blanche discretion to some agency or some individual to determine who gets a permit and who doesn't. The rest are just your standard time, place, and manner restrictions that must be content neutral, narrowly tailored to serve a significant governmental interest, and lastly, leave open ample alternatives for communication. The constitutional grounds for denying a permit, the grounds for denying it in the permit ordinance itself or in the permit scheme itself must be set forth very narrowly and very specifically. It must say permits will be granted except for where there's multiple uses and it's a first come first served basis, or where the event or the desired activity is going to so interfere with public safety or traffic concerns that it would be denied on those grounds. In the Shuttlesworth case, backing up to the first point, the city of Birmingham had a permit ordinance that basically allowed for the governing body, the police agency or the city, to grant or deny permits for whatever reasons they want. It didn't require them to set forth the reasons for denying a permit. So if the city officials didn't like your message, they could easily just say, we think this will cause a traffic hazard, you're denied, and not have to set forth any reasons justifying their denial. The court in that particular case did an odd thing, and during the arguments, the city said, oh no, we really interpret it to mean this, and they sort of fashioned their arguments to narrowly constrict this really broad statute. So the court said, well, if you're only going to enforce it that way, we'll let your ordinance stand, but they did reverse the conviction for the person who had been prosecuted under that ordinance for failing to get a permit. The second prong, you must have evidence to support the denial. In the desert outdoor advertising case, it was much like Shuttlesworth, where they had a billboard sign ordinance, and they left open to the city to determine what signs would violate the aesthetics or the beauty in the community. And so if they didn't like the message on your sign, they could very easily deny you a permit for a billboard. And the court said, no, you need to narrowly tailor that ordinance and set forth all of the grounds for denying the permit. And lastly, the city or the permit ordinance cannot give unfettered discretion to the officials to determine the cost of the permit. In the Forsyth case, it was basically left open to the city officials to decide if you're having a smaller event, we'll charge you a lesser fee, or if you're having an event that we don't agree with your message, we'll charge you an exorbitant fee. So, and it was not tied to any particular governmental interest, so the court struck down that permit ordinance. Discretion is permissible. City officials are going to have to either grant or deny these permits. The question really is there a specific articulable purpose for them, and is it in writing so that it doesn't look like you're giving one particular administrator the ability to discriminate on the basis of viewpoint. Some permissible reasons for denying permits or giving discretion to a city official would be to coordinate multiple uses, like we talked about, preventing unlawful uses, and protecting public safety. So if you're allowing a city the ability to decide to grant or deny, those are the reasons why you would allow them to exercise their independent discretion. Some specific pro-life activities and potential problems. We saw a little bit of this earlier: leafleting, picketing, chalking, sidewalk counseling, and life chains and vigils. So there's some potential problems, and with all of these various activities, you may run into some resistance from law enforcement. They don't like you standing in front of residences with big, large yellow signs saying an abortionist lives here. We've come in a lot of conflict with the chalking lately. You would think chalking on a sidewalk is perfectly permissible. There are 5-year-olds who hopscotch every day in this country. There's not much difference between a hopscotch and a Happy Mother's Day message or a Choose Life message, but most recently down in Southern California, the police have just been coming after us, alleging this as vandalism and graffiti. So we'll talk about some potential problems with each of those activities. Some problems would be sign ordinances when you're standing outside of an abortion clinic, or when you're picketing, like Katie described earlier. She had a client who was restricted to literally a 3-foot square sign. Permit requirements, which we just spoke about, noise restrictions, obstruction laws, and bubble zones. So we'll talk a little bit about each of those various potential problems in light of the pro-life activity. Sign ordinances. Cities may have laws that restrict the number of signs, the types of signs, the size of your signs, how you hold your sign, what you do with your sign. We've seen all sorts of different ordinances restricting the use of signs. Most of these ordinances, though, if you look at the very bottom, will apply only to commercial or election signs. There's sometimes an exemption at the bottom that says it doesn't apply to non-commercial free speech signs. And once again, these ordinances cannot discriminate on the basis of content. So, like what Katie was saying, there may be an ordinance that says that this applies to everything, and then the exemptions are like, it doesn't apply to this sign and this sign and this sign, and it becomes content-based by virtue of the exemptions. So look for that. That's a issue that we're going to be possibly litigating down in the city of San Mateo, where they have so many exemptions. And the law itself is so broad, it basically prohibits you from even driving your vehicle through the city with a bumper sticker on your car, because that's considered a sign. So that would be something to be wary of in terms of sign ordinances. We had also a situation out in San Bernardino where they tried to say that you could not hold your sign on the sidewalk. You could not let your sign physically touch the sidewalk, because that would be posting a sign, which was illegal. The police officers literally came over and made everyone hold the sign on their toes, 1 inch above the ground, because they said that otherwise it's unlawfully posting. We fought the case. Somebody was arrested. We challenged the law, and it was eventually thrown out. And the city of San Bernardino paid a large sum of money to us and our clients. So you just have to be aware that these are some issues. When somebody doesn't like your client's message, they will try to misapply the law to harass and intimidate your clients and just try to get them to walk away. So, obstruction and loitering laws. I have to chuckle. This picture that you see up here, this is a real case where we had a client who was holding one of these signs and was accused of blocking the sidewalk and obstructing the sidewalk. Now, you see there are huge families with ice chests and coolers and chairs, and the sidewalk is clearly being used and isn't being obstructed by the people holding the signs. They have them off to the side. Other people can pass by. But we had an irrational judge who thought this is partially blocking the sidewalk, which was illegal in this particular city. Be aware of these types of obstruction, or sometimes they call them anti-loitering laws, whenever your clients are engaged in activity on public property. Cities do have a significant interest in regulating traffic on sidewalks, on streets. Had these signs been at an intersection where vehicles were driving by and couldn't see if a pedestrian was going to come out into traffic, that could be a valid interest. So it's something to look out for. But at the same time, back when we were talking about the permit ordinances, one thing that you need to look out for with these obstruction laws is look out for ordinances that give sole discretion to the police to decide what's an obstruction and what isn't. And that's one of the main problems that we had with this particular case that's shown in the picture, is that they really didn't have an enforcement scheme. It was left up to the police officers themselves to decide, oh, well, we think you're just a little too large to stand on the sidewalk and you block too much of it, versus somebody else walking down the sidewalk and says, well, we understand that you're just passing by, or you just stopped for 10 minutes as opposed to 30 minutes. We'll let it slide and not enforce the law against you. So the ordinance itself and the enforcement of it was really unconstitutional, because it gave sole discretion to the police to decide who they were going to write a ticket to, basically. Like I said before, harassment and threats of arrest are extremely common, particularly with pro-life advocates. So it's very important to know the laws in your community and to develop a strategy for challenging the ones that you deem to be unconstitutional ahead of time. It may not be the wisest scenario to have 50 people go to an event and have all 50 clients in jail, and you struggling to find 50 attorneys to represent all of them because of all the various conflicts of interest. So it's really important, if you have a client who comes to you and says, I want to plan this event, this is the city where it's at, this is what the type of activity that we're looking at engaging in, to research the laws and know what sort of pitfalls you might be up against, and to know whether or not you should challenge that ahead of time before the event. You always want to maintain, always remember what the objective is, and you don't want to be distracted in the middle of an event where you're trying to get a very good message across by law enforcement pulling people away and threatening them with arrest, even if it is unlawful. The next category is noise restrictions. Most cities have laws that limit noise in particular areas, whether it's across from residences, near a school, in front of the local courthouse or city hall. And most of them regulate the use of sound amplification, using sound amplification devices. One recent case that I saw out of the city of Laguna Beach, actually, the city of Laguna has an ordinance that prohibits the use of a bullhorn in front of a school 30 minutes before and 30 minutes after school. And the court struck down that law and said that it was not narrowly tailored, and it served no purpose. If you want to keep noise levels down during school hours, that would be a legitimate reason. But to prohibit the use of a bullhorn before school even starts or after school is already let out, you're not disrupting the education environment, and so they struck down that law. No, I believe it was a street preacher. Some California state laws that may also apply to your client's behavior, or they may be threatened with arrest under these various statutes, include obstructing passage to healthcare facilities, trespass, interference with business activities, and the California FACE statute, which we will talk about a little bit later. And then lastly, vandalism, which we touched on a little bit. The requirements under trespass, there's probably about 30 different forms of trespass, and most frequently none of them will apply, but police officers often aren't educated. They just think, you're on somebody else's property, you're not allowed to be there, I'm going to arrest you, they want you gone. When in actuality, if the property is open to the public, that's normally an exception. You can't be a trespasser if the property is open to the general public and you're not interfering with their business. And the interference with business activity is very narrowly interpreted as well. Clearly, if you have a sidewalk counselor who's in front of an abortion clinic, their goal is to interfere with business activity. They want to lure people away and prevent them from going inside and give them alternatives. That is not a violation of the law. They actually have to be blocking entrance, prohibiting people from going inside. Merely standing on the sidewalk and handing out literature or speaking with individuals doesn't rise to the level of interference that is necessary for criminal liability. And I would argue likewise on the vandalism for sidewalk chalking, we might be forming some sort of a challenge to this, or at least getting a court to rule on it definitively. Right now it's a gray area in terms of whether or not chalking is considered graffiti under the California Penal Code Section 594 for vandalism. Our argument is that it's not permanent, it washes away, and it's definitely not within the scope of what the legislature intended when they enacted that statute. And you just have a real issue of unequal enforcement. Are you going to then ban sidewalk chalking on every single sidewalk in every single city or county in all of California? It just doesn't make sense. So we're hoping to be able to get a case where we can challenge that and get a court to rule that sidewalk chalking is a form of free speech and it does not amount to vandalism. So, other local ordinances, depending on what city you are in, I know the city of San Marcos has an anti-loitering ordinance, and we challenged that and got them to back off. It literally just was so vague, it prohibited people from walking into a parking lot and standing there for too long. And so we had these sidewalk counselors who would walk in for the purpose of engaging in conversation with an individual, and as soon as the conversation was over, they would leave. So they weren't just wandering about in this parking lot, they actually had a purpose, but the statute was so vague that the police officers just didn't know what to do. They arrested the person, cited them, and then we ended up having a challenge with the city attorney's office, and they backed off and dismissed the case and agreed not to enforce that ordinance against the sidewalk counselors down there. Glendora has a mobile billboard advertising prohibition, and this is something that we're seeing creep up a lot as well. This is probably one of the latest attacks on what I would call them the truth trucks, like what Katie was talking about in the CBR case. These are individuals who drive a vehicle around that have pictures and slogans all over the vehicle. Well, in the city of Glendora, you're not allowed to have any mobile billboards on your car. So if you drive through the city and you have an advertisement on your car, you're in violation of this law, which becomes really problematic as well, because then you have people who don't necessarily know about the law. Somebody who has a bumper sticker on their car, does that qualify as a mobile billboard? Somebody who has a license plate frame that has a slogan on it, does that qualify as a billboard? So we're currently challenging that law in the city of Glendora, and we'll see how that ends up as well. And then, like we talked about earlier, the Laguna Beach sidewalk obstruction law. Just be aware that there are these local ordinances out there that you would never have even thought of, and you should be aware of them because they could impact your client's activities significantly. And one way that you can be aware of them is by doing a search online. It's very simple. Most of the cities have their criminal codes online, and any state statutes that you may not be aware of, those are also online. So these statutes are found in really sometimes hidden places. So some words that you might use to locate these laws would be public peace, public welfare. I think I used the word handbill, actually. Somebody called me just yesterday asking me if it was illegal to put leaflets on vehicles. And I was thinking, well, what are all the words that you could use for leaflet that a city might use in their ordinance? And handbill is something that they often use. So I just Googled handbill, and lo and behold, there's a complete prohibition on passing out handbills anywhere. Whether you're standing, whether you're putting them on a vehicle, whether you're on the streets, on the sidewalks, and it basically prohibits leafleting in the entire city, which is completely unconstitutional. So we just advise the person to go ahead and go about their business until somebody tells them to stop, and then we'll have a discussion with the city about the constitutionality of their law. And Katie's going to come up and talk to you about bubble zones. Did you have a question though first?
Have you heard any rationale advance for the mobile billboard ordinance? Because it seemed to me that even a Safeway truck driving through town could be cited under that theory, at least with Safeway on the side of it.
They do. However, there are exceptions within this mobile billboard prohibition for vehicles that are displaying the business of the owner. And as long as you're not just driving through the city for the purpose of advertising, but you're actually going about your ordinary work, they exempt that sort of activity. But if you think about it, I mean, every sign has a purpose of advertising. Otherwise, why would you use the sign, or why would you not use the sign? So it's going to become very difficult to enforce if a person is driving through the city and just has many bumper stickers on their car. Yeah, they put the bumper stickers there to advertise, but were they going somewhere else? What happens when they invoke their Fifth Amendment right? Do you always have to, have your itinerary out and prove that you were going to a legitimate location and not just simply driving about the city? So,
does a law like that have to have a specific intent element?
On which one, the mobile sign?
That Glendora, yeah, the prohibition, but can it...
Yes, you have to intend to advertise. That's the intent that it requires.
Oh, so you could still not know that it's illegal, but have the specific intent.
And if you think about it, I mean, every person has the specific intent to advertise by putting a sticker or a sign on their vehicle. The problem that we're running into with that particular Glendora ordinance is the way that it was brought up in a criminal context, first of all, because the gentleman was cited for it, and the way that the criminal court applied that particular ordinance, it actually elevated commercial speech over non-commercial speech. And we argued that his speech, he's just advertising his business, basically. He's a pro-life activist, and he's advertising his business, no different than Joe the plumber driving down the street with Joe the plumber on the side of his car. And the court said, no, the exception to liability is only for commercial purposes. You actually have to have a business like Joe the plumber or Bob the builder advertised on your vehicle. It can't be a non-commercial message. So it'll be very interesting to see how that case ends up.
How about like protect and defend on the police car at the city logo?
It's funny that you bring that up, because when you that's exactly the sort of scenario that we're talking about with the sidewalk chalking. It happened in front of an abortion clinic, and it was pro-life messages, and the police came out, and it was actually Katie's daughter who was cited. Well, not cited, threatened that we're gonna, file a report on this and send this to the DA for consideration. And I doubt anything will ever come of it, but our idea would be to have a police appreciation sidewalk chalking event outside the city police department. And so I was going to bring out, a bunch of 8, 9, 10-year-olds to sidewalk chalk hopscotches, but I love the idea of actually bringing it to the police department. Are you going to arrest all of these people who are saying thank you for doing a great job? Probably not. And then you can demonstrate the unequal enforcement of the law. So.
These permits you're talking about, do you challenge them, or do you say these are legitimate, are they constitutional or not? The permit requirements, you talk about, for one that says a group of 50 or more. I mean, who decides 50? It's not arbitrary. Has that been challenged?
It just depends on the exact wording of it. Those are situations where you might need a permit, and so if you're planning an event that's going to have 50 or more people, it's probably a good idea just to look in your city code to see if they do have one. And then depending on how it's worded, if it's unconstitutional on its face, you can challenge it without actually applying for the permit ahead of time. For example, if it gives unfettered discretion to the government official, you don't actually have to apply for and get turned down before you can challenge the law. Now, if you're just saying that it's not, there's no legitimate purpose for it, it doesn't serve a significant governmental interest by requiring the 50 or more,
that's my question.
You would have to apply for it first. You would have to apply for the permit, get denied, and then show that there's no legitimate reason or no significant governmental reason, interest in regulating demonstrations.
My question remains, is it generally just a fluff thing to make things a hassle, or do you think these permits are legitimate?
No, I think in most cases it is legitimate, because you only see it for those numbers when they're regulating. They also have in their code section for the 50 or more when you're regulating multiple uses of an area, whether it's for a park, whether it's for a sidewalk. Most often it's in a park, though, or a public square where they don't want 80 different groups just converging without some semblance of order. Yes?
In your slide on obstruction and loitering laws, you
Yeah.
have a picture with the family with the coolers.
Yes.
And I believe that you said that the judge determined they were partially blocking the sidewalk, which I'm just questioning if that law, partially blocking the sidewalk, you're saying that would be unconstitutional? I mean, they were partially blocking the sidewalk.
No, we weren't representing the family. We were representing the individuals with the signs on the side. And so our argument is that every person, just by virtue of their being, takes up space and partially obstructs the sidewalk. That law is just so vague and overbroad that it virtually bans, the usage of any sidewalk within that city. So that was our argument, is that it just left open to the discretion of the officers who they were going to give a ticket to or not, because it virtually banned just walking down the street because you partially obstruct the sidewalk by using...
So the folks with the coolers just happened coincidentally to be there?
Yes. Yes. And our argument was that it's not obstructed at all. There are huge families with coolers and chairs and everything using the sidewalk.
And they were just like hanging out there with their chairs?
They were walking.
Oh, okay.
They were walking. Yeah. So, okay. Katie's going to come and talk to us about bubble zones.
Well, actually, I wanted to, just a couple of things that reminded me of when Allison was talking. When she was talking about having to hold the signs up in that one place. The distinction where there's a sort of uncertainty in the law right now is between attended and unattended signs. We know from a Supreme Court decision in the 90s that it is legitimate for cities to ban the posting of signs. In other words, if they want to say no one may post a sign on a telephone pole, utility pole, city property, something like that, that is okay. On the other hand, we know that you can't ban picketing as in holding a sign. So there's this area in between, which is, what about if I just place a sign on the sidewalk on an A-frame or something like that? Can I do that? And this is simply still open. Our argument is that again, between attended, that it's not between posted and held, that there's attended and unattended. And that the reason the Supreme Court okayed the banning of posted signs is because, as the court said, they are left unattended. It contributes to visual blight. It contributes to litter if they blow down. It causes problems. And our argument is that those problems don't exist when you're talking about a contemporaneous demonstration where people are there. They can prevent the sign, if it falls down, or they can prevent it from falling down. They can make sure it doesn't block the sidewalk. That there are more narrowly tailored ways to deal with any potential problems with signage when you're talking about a contemporaneous demonstration. And also, in terms of contemporaneous demonstrations, although aesthetics is probably the primary justification for sign laws against the posting of signs, no court has ever held that their city has any aesthetic interest in limiting or restricting in any way a live demonstration. That there's no way you can just say, well, picketing is ugly, and so we're going to limit it. There's no aesthetic interest in limiting, live, ongoing demonstrations. And just one final thing, when Allison was talking about how we've dealt with various situations, when these situations come up, and they can be resolved in any number of ways. Probably the least common is the full-blown lawsuit. More common is then you have an arrest where we deal with the city and it turns, the charges are dismissed or something like that. Then you have just a letter, to the city, or a discussion with the city attorney. And frequently, we can resolve a lot of problems that way. So there's various levels in which you can deal with these problems. And now it's time for a little quiz. Okay, I got some examples here of activity. Then you tell me whether you think it's legitimate for a city to put this restriction on a speech activity. First of all, how about a keep moving restriction, saying, yes, you can hold a sign, picketers can hold signs on the sidewalk, but they must keep moving while they're holding their sign. How many think that would be legitimate? No one. Okay. You think okay. And illegitimate, can't do that. You're right. Okay. Well, I'm sorry?
In every situation, it would seem like there might be some situations where it might be legitimate.
Well, I'm just talking just as a general citywide law, if you're going to have a sign, if you're going to be holding a sign on the public sidewalk, you must keep moving. And the Ninth Circuit specifically struck down a keep moving requirement in the case of Fody versus Menlo Park. How about this? You have a licensee who has got a license for the downtown area to hold a street fair or sidewalk market or something like that. So it is a street, public street, but some private organization has licensed the area for its use for a particular time. Can they exclude people from, and it's an event that's open to the public, can they exclude people from coming into that area for the purpose of leafleting or speaking or walking up and down with signs or something like that? You think they can exclude that? I think they can't exclude that. Okay. No, the answer is no, that as long as it is, you can't exclude a speaker or leafleter or someone gathering signatures on a petition from being present in an area that is actually public property, traditional public forum property, even if it is currently, has a permitted use by a specific permittee. Like leafleting cars on public property. So these are kind of funny examples of public forum. You've got private property, but it's parked in a public area, on streets, public forum area. So can a city ban leafleting cars? How many think they can? How many think they can't? Okay. Yeah. Yes. The Supreme Court struck down in Klein versus City of San Clemente a law that banned leafleting cars that were parked on public property.
Is that just an extension of Prolife or?
No. This is it was a Ninth Circuit decision. It was saying it was based on First Amendment principles. So they didn't, though they applied the traditional time, place, and manner test. They actually didn't really rule on whether this counted as a public forum or not. They just said it's a sort of free speech activity that is protected under the First Amendment, and that the law was not narrowly tailored to serve the city's interests. Now, on to the bubble zone laws. This now, when we move into the bubble zone, we call them Mother May I laws. They're laws that say you must get before approaching someone who is seeking to enter a healthcare facility, you must first get their consent before approaching for the purpose of protest, education, or counseling, or handing a leaflet, or distributing literature. And these laws will now undercut everything we've just told you in the first hour of this presentation. The fact that these laws have been upheld. Well, sometimes, more generally, we do have laws that simply prohibit activity around healthcare facilities in general. But the bubble zone laws are the ones that seem to be proliferating most. It's this idea of you cannot approach without consent. And the really disturbing thing is that in 2000, the Supreme Court upheld one of these laws. It was a statewide law in the state of Colorado, and it applied to all medical facilities. And it was very broad. It said just within 100 feet of the entrance of a medical facility, it didn't even have to be someone going in or out, just within 100 feet, is unlawful to approach another person without their consent for the purpose of protest, education, counseling, handing a leaflet, displaying a sign. And it's spread to other cities now, but the Supreme Court upheld this law in Hill versus Colorado, and in doing so, again, just violated pretty much every principle we've been talking about. First of all, in terms of the narrowly tailored to serve a significant governmental interest, the governmental interest that the Supreme Court said was being served by these laws was the interest in being left alone on a public sidewalk, an interest that had never before been recognized as a governmental interest. In fact, had been rejected by the court a few years earlier. The second thing is that the court said it was not a content-based law. It was, even the fact that it specifically talked about protest, either the sort of speech that was restricted was protest, education, or counseling. And the court said that is not content-based. And which it clearly is content-based, because there's some speech that is that and some speech that isn't that. And the court in this case was willing to countenance a certain amount of non-content neutrality, and said, well, we have never held that you can't look at all at what speech is, determine if a law is, if conduct is violating the law. Well, that may be the case if you're talking about speech that is, unprotected threats, obscenity, fighting words. There are these categories of unprotected speech. Yes, in those cases, you would definitely look at the speech to see if you're talking about the violation of a law. Or you might have something like securities fraud, insider trading. There are certain types of speech. But in this case, what was so bizarre is that the Supreme Court said, we will look at the speech that they were looking at is speech that is at the core of the First Amendment. It is speech that is at the core of the First Amendment that leads to the violation of the law. If you wanted to walk up to someone and ask them what time it is, that wouldn't be violating the law. If you want to walk up to someone and hand them an informational brochure, that would be violating the law. That's what was so topsy-turvy about Hill versus Colorado, and such basically a betrayal of decades of First Amendment jurisprudence. I was, and this topsy-turviness extended to the lower court cases. There was Edwards versus City of Santa Barbara. That was a case that limited demonstration activity in around healthcare facilities. And I read a deposition in that case where a police officer was asked how could he tell if what the person was doing was demonstration activity or not, the prohibited activity. And he said, well, basically, if it's protected by the First Amendment, then I know it's against the law. That was what it came down to, because it's prohibiting the very core activity that the First Amendment is intended to protect. In Brown versus City of Pittsburgh, they actually tried a sort of a combination of two laws. They had the no approach law, plus they had an absolute bubble around clinic entrances, a 15-foot diameter or radius bubble. And the court actually struck that one down, in effect saying choose one or the other, because the combination of the two makes it impossible to reach people. Because, excuse me, I should back up here. One more thing about the Hill case. In the third prong of the test, we talk about content neutrality, narrowly tailored. Ample alternatives in Hill. What the court said was, well, what do the people want to do here? They want to, hold signs, hand out literature, talk. Said, well, signs can easily be seen from 8 feet. Voices can be heard from 8 feet. Leafleting they admitted was a problem. It's hard to leaflet someone from 8 feet. So they said, well, people can simply stand by the entrances to the clinic and, without blocking them, proffer material as people go by into the clinic. And that was the sort of solution. That's how this, there was an ample alternative. In Brown versus City of Pittsburgh, they said, well, if you're going to put 15-foot zone around, and then you have a no-approach bubble around that, or no approach zone around that, there's no way to, say, stand near the entrance when people are coming in and hand them information, because you've just made the entrance effectively huge. So that's why the court struck down the bubble zone in that case. But I think the city has since gone back and simply reenacted it with one or the other. I can't remember now which. This represents probably the worst and scariest development is in Massachusetts. They originally had a no approach law that was passed in about 2001, but they upped the ante. They did two things. One was they made it apply only to abortion clinics. And when Hill was decided to apply to all medical facilities, and the court said, that's neutral enough. It's not saying that anybody, it's medical facilities, because patients need to, have some calm when they go into clinics and things like that. And even though the dissenters were saying, hey, we know what this is about. It's about abortion protesters, and in fact it was. But in McCullen, they sort of stripped away that and just had it apply only to abortion clinics. They also then made an exception. I'm sorry, this is the predecessor's case, McGuire versus Riley. They made an exception for clinic employees. So written into the law was this exception. Again, so they betrayed even the facade of content neutrality by changing the law in those two ways. Only abortion clinics, exception for clinic employees. First Circuit upheld the case, but it gets better. In 2007, they decided that wasn't enough. So they passed a new law that simply erected a 35-foot zone around the entrances to abortion clinics and said no one may go in them unless you are working for the clinic, going to the clinic, police and fire, or just passing through on your way from point A to point B. So it's absolute no entry zone within 35 feet of the entrance to abortion clinic. And the First Circuit upheld that law, and it's narrowly tailored. I just went through all the criteria: content neutral, narrowly tailored, leaves open ample alternatives. Again, when a court wants to, it can find anything it wants. So, and unfortunately, cert was denied. I believe the parties are now trying to put together. That was a facial challenge. They're trying to put together an as-applied challenge to that law right now. But very scary development in the law. So then, that brings us to Walter Hoy's case here in Oakland. The city of Oakland passed a no-approach law, and it applied only to abortion clinics, and was directed at Pastor Walter Hoy, who would go out to a clinic, and he had a very, very mild approach. He would just walk up to a woman and say, "Hi, my name's Walter. Can I talk to you for a few minutes?" And this enraged the clinic. Then the next thing, they recruited a number of escorts to interfere with his activity. And so he started carrying a sign. This sign, "God loves you and your baby, let us help you." Just because he couldn't, they were making it very difficult for him to walk up to him. But even that wasn't good enough, so then they passed this ordinance. The problem was that, again, unable to resist twisting the knife a little, they initially, in their first rendition of the ordinance, said, for the purpose, when the part about no approach without consent, for the purpose of protest, education, or counseling a person not to use the services of the facility. So it became blatantly viewpoint based. And we brought a lawsuit the day after the law was passed, had a TRO hearing 2 days later, and the judge strongly urged the city to reconsider its position, and they said, "Oh yeah, we'll take care of it." And so then they passed the law again, striking out that language. But we challenged it again because we still, for a couple of reasons. One, we thought on its face, this idea of applying only to abortion clinics, yes, the First Circuit had said it was okay. We wanted to get another circuit's opinion on that. Meanwhile, however, Walter was arrested under the ordinance out there at the clinic. And so we had a criminal trial in which we got all sorts of great testimony from the escorts because they weren't being coached by the clinic's attorney. They were. It was a criminal trial, and the testimony from the escorts was very clear about what their intent was. That their intention is to block. Their intention is to prevent women from, not just prevent Walter from communicating with women, but they actually say prevent women from seeing his sign. Prevent women from hearing him. They were very clear. They meant to create a complete barrier to communication. Walter was convicted, but then his conviction was overturned on appeal because of the prejudicial error of not requiring the DA to single out a particular instance in which he had supposedly violated the law. The jury was allowed to sort of pick and choose among a whole number of supposed incidents that the DA put forward. And
how did jury selection go in that? How were you allowed to select the jury?
You know what? I will let Allison answer that question one of the times. I mean, I was there. Allison wasn't. She was in charge of that. So
obviously, a really critical thing. So I'll
okay.
look forward to hearing that.
Yeah. Well, let me just give you one. I think we went through about 60 jurors in the whole voir dire panel. Of 60 of them, 2 of them had actually served as clinic escorts. And we had 2 who I think 2 confessed to pro-life beliefs, in some general way. But that was kind of the balance we were dealing with.
Excused for cause, those 4 that you just described?
Yeah. Well, they practically excused themselves. They said I couldn't be fair, because boy, I've been out here. I've seen what these people are like. Thanks. Thank you. Excused juror number 6.
Were the pro-life persons excused for cause?
I don't remember the cause, or I can't remember whether the DA did. Yeah. Anyway, then fortunately, we had, as I noted, we had already brought our our federal lawsuit by the time that Walter was arrested, and because otherwise we would have had a big problem with federal abstention. And this is something to be very careful about if you're thinking, when you're thinking about, well, go out and challenge that law through a criminal means. When you do that, that person who is being arrested is, until that matter is resolved, and, well, it's even more complicated than that. That person probably is not going to be able to be your plaintiff for challenging the restriction because of federal abstention. The federal courts say, we will let you should make your arguments in state court because state courts are just as good at resolving these things as federal courts are. So you have to be very, very cautious about that. And again, we challenged the law immediately, and his arrest didn't take place for 5 months after that. So we were, very, very fortunate that we had that lawsuit up and running, because the courts have even held, if your federal lawsuit is still in an embryonic stage, that they may abstain if a criminal prosecution starts. Anyway, we were in the civil lawsuit. We challenged it on a number of grounds, including, again, application only to abortion clinics. That, and the fact that the city's the original law was blatantly viewpoint based. That this, the whole intent of this thing was to squelch speech for a particular viewpoint. We also, the other problem was that the city wasn't enforcing the law against the pro-abortion escorts. They would walk right up to women and say, here, let me help you in the clinic, don't listen to him, don't take his information, and the city didn't enforce that. We first observed that on the street, and then we took the deposition of the police, a police captain. We did what's called in federal court a 30B6 deposition. It's kind of the equivalent of the state person most qualified deposition, person most knowledgeable, person most qualified, and somebody testifies on behalf of the city as to certain matters. And from there on, it's not Captain Toribio said, it's the city said, in its deposition that such and such. And in doing so, we got some just wonderful testimony about their way of interpreting that. It did not apply to escorts because escorts were there to facilitate access. So of course it wouldn't apply to them because that's what the ordinance is all about. It's about facilitating access. They're facilitating access, therefore it doesn't apply to them. And we actually was very helpful. The city objected to all our questions, but we got a good ruling from the Ninth Circuit. Before I get to the major ruling, that was one of the rulings. The minor rulings we got from the Ninth Circuit that those sorts of hypothetical questions are permissible because the court said that's when you're questioning a city about its policy. That's really what you're saying is what would you do in a certain situation. And so the court said we would be setting a possibly high bar for plaintiffs if we were to require them to establish a municipality's policy and then to exclude as inadmissible a responsible police official's testimony as to what the municipality's policy is. And so that was very helpful and will, I think, be very helpful. The main rulings in the case were that, yes, that it was that the city's enforcement policy was content and viewpoint based, and no, I'm sorry, okay. Kind of viewpoint based, and that a secondary ruling we got, which was also very important, we argued that while in the Hild case, the Supreme Court had said, oh, these ample alternatives, you can hear voices from 8 feet, you can see signs from 8 feet, you can get literature from 8 feet, or stand by the entrances and get literature. Our argument was, well, that works well and good in a pristine situation where there's no one else on the sidewalk. But here's our situation on the ground. We have these escorts who, as you could see from their testimony, their entire function is to block communication and to prevent this from taking place. And so they are trained to, they're recruited to do that, they are trained to do that, and this is what they do. And so our argument was that this is a as applied special circumstance on the ground that makes this ordinance unconstitutional right here. Even if it's constitutional on its face, here and now it is unconstitutional because our client has no opportunity to reach women. If he can't walk up to them, and meanwhile the escorts are blocking and interfering, then it leaves no alternatives for him. Yes?
Did you have video evidence?
We sure did. Yes, we had videotaped the entire day. Actually, the dates of that Walter was arrested, as a matter of fact, were on videotape. And you could see the escorts walking up and down, holding cardboard signs in front of his sign to Brett. And even when he was just standing on the sidewalk doing nothing, you have these escorts holding their signs in front of his. And then whenever a woman would walk up, some would surround the woman, some would surround him. So we did, and we put that into evidence, and I think that's probably one of the other benefits of the case, to the extent that we certainly hope that someone up there at the Ninth Circuit watched those videos, because we made the point that you cannot understand what is happening unless you watch these videos. Words do not do the trick. So yeah, we did have the video. Anyway, so the court ruled that the lower court had said no, that basically what the escorts are doing, it's not state action, this or that. The Ninth Circuit ruled in our favor on that issue and said that yes, the escorts' misbehavior, their conduct, could be considered as a factor, a special problem in holding that the law was unconstitutional. But they sort of punted on whether we were there yet. They said it was like, we'll send it back down and see how things work now that we've ruled that it has to be applied against both sides. Come back to us again if you can show that in fact the escort's conduct is still preventing him from communicating. So, and we had. Oh, actually, I'm sorry, I have a little note in here. One more thing that I learned only in the oral argument, or preparing for the oral argument in this case. Who has the final say on what a city law means, on the correct interpretation of a city law? The reason I ask this is that the city kept saying, you're looking at a law that, with some distinctions, you would say, okay, this is the same as what the Supreme Court upheld in Hill. I mean, there were differences, but let's just presume at its core that it was the same. However, you have the city saying it means that escorts are exempt. It means it doesn't apply to speech that facilitates access. And the city is telling this, that is their interpretation of the statute. And so the question is, is that the final word? Does the statute mean that? And then you could say, okay, well, if that's what the statute means, then it's unconstitutional, which is what we argued. Okay, then it should be unconstitutional on its face because the city is telling us that's what it means. So apparently, however, I learned that it is actually the state Supreme Court which has the final say on what an ordinance or a law means. So the lawmakers can think it means one thing, but ultimately it's the state Supreme Court who has the final say on the correct interpretation of a statute, which is kind of an interesting situation. You could have, again, the city is there telling us it means one thing, but if the state Supreme Court says it means something else, they have the final word. Yes?
So how does that work logistically? If you're in federal court, I mean, when are you going to get the state Supreme Court to decide that?
If the Ninth Circuit decided to certify the question to the state Supreme Court to find that out, and when at the oral argument for the case, when you're sort of there in the fog of battle, it's not so clear. But later on, I suddenly realized that we spent the first 10 minutes, 15 minutes of argument just discussing the procedural ways they could not rule. In other words, maybe we should, federal abstention maybe we should certify this. It was all the ways that they could avoid ruling. So, and that was one potential way, was to certify the question to the state Supreme Court and boot it over there for a while. So, what the Ninth Circuit did instead was they said, well, yes, the city is saying that, but basically the city is wrong. The ordinance doesn't mean that, but they said it does present a remedial puzzle because you don't have anything in writing saying that this is what the ordinance means, but the city is telling us what this means. So how do you solve that? There's nothing that we can draw a line through to get rid of this. And so they ended up just booting it back to the district court for the district court to figure out what to do with it. It said enter declaratory judgment for Walter Hoyd that this enforcement policy was unconstitutional, and then if that's not good enough, you can enter an injunctive relief. So what we finally ended up with was the city came up with new training materials for their police. Well, have I got time for that little? What happened was we went back, so it was sent back to the district court, And the city is supposed to come up with their new training materials, which is like the only official manifestation of what their enforcement policy is. And it was set for a CMC, and where they were supposed to then present to the court. And the idea was, okay, we've got it, we got it now. We understand when the court will simply sign off on these new training materials. And they sent us over the training materials a few days ahead of time so we could comment on them. And the training materials said, and you have to understand, again, the training materials never said anything before about having an exemption for escorts. It's just everybody knew it. The cops on the street knew it, Captain Rubio knew it. It was just known without it ever having been written anywhere. So it was very important what actually gets in writing. So the new enforcement policy said, okay, the law applies, spell out the restriction on approaching without consent, and said this applies to all persons, including escorts, but not clinic doctors, nurses, or employees. And so we said, wait a minute, no, it does apply to them. It applies to everybody. And they said, oh, no, that's not what the Ninth Circuit said. That's not what they meant. That's not what. And so we had a whole other battle with the city over this before they finally, it involved us having to we actually brought a motion for a permanent injunction saying, okay, the city still doesn't get it. The only way to make, you cannot trust them to get it right. So just enter a permanent injunction against enforcement of the ordinance as a whole. And by then the city wised up, and then all of a sudden it's like, oh, no, that's not what we meant at all. So they managed to patch thing over before the hearing, and so we ended up with just new training materials that simply doesn't say anything about clinic doctors, nurses, or employees. It just says it applies to everyone. But I still think it's a problem because their old materials didn't say they had any exemptions either. But anyway, that's where the Hoy matter stands right now. And I think that brings us to our break.